Hello, everyone, and welcome to the ABA Senior Lawyers Division webinar, Trusted Contacts Person as a New Tool for Protecting the Investment Accounts of Seniors. This webinar is brought to you today by the ABA Senior Lawyers Division Committee on Financial Services and Retirement Planning, which examines financial services issues that all retirees must consider, including investments and tax implications. Our speakers today include Chair of the Committee, Marty Cohen, and the SLD Council Member, Carrie Peck. Carrie is the Managing Partner of the Chicago law firm Peck Ritchie, LLC. He concentrates his practice in trust and estate litigation, estate planning, administration, guardianship, fiduciary litigation, and special needs and Alzheimer's disease planning. He is the chair of the state's attorneys Anita Alvarez's Elder Abuse Task Force. He is retained by the City of Chicago Department of Aging to rewrite the Illinois Elder Abuse and Neglect Act. He co-wrote the book Alzheimer's and the Law, published by the ABA. Marty is the chair of the ABA Senior Lawyers Division's Committee on Financial Services and Retirement Planning. He is the past chair of the Real Estate Committee of the ABA Tax Section. He has practiced in areas of taxation and bankruptcy as a member of the Milbank, Tweed, Hadley, and McCloy in New York City. He has taught tax law at NYU, Miami, Florida State, and Quinnipiac law schools. He is the author of more than 40 published articles on taxation. Thank you both so much for being here. With that, I'll turn things over to you, Marty.
All right, thank you. Today's webinar is going to deal with the new FINRA rule requiring. I'm sorry. Let me start again. What you need to know about trusted contact persons. Thank you for joining us for today's webinar, dealing with the new FINRA rule requiring financial institutions to allow individual investors to designate someone with whom the institution can exchange confidential information about themselves. Technically, the new rule applies to almost all non-institutional accounts, including trust accounts, checking and savings accounts, and others, and not necessarily accounts for primary beneficiaries who are over 65. However, today's webinar will focus primarily on brokerage accounts held in the name and for the benefit of an individual over the age of 65 who may be a current or future victim of a financial predator. Before getting into the FINRA rule, try to review why this rule is necessary and perhaps doesn't go far enough. To that end, we will first hear from Carrie Peck, who will summarize some of the problems that investors and especially seniors encounter in trying to preserve their assets from financial predators. Carrie?
Good afternoon, ladies and gentlemen. Thank you for joining our webinar today. As Marty said, we're going to talk about the trusted contact persons issue, and fundamentally, I think we need to address this in the context of why was this rule enacted, and Marty's going to talk about that, but I'm going to talk about the exploitation and the vulnerability of older adults. By the age of 85, over half the population will have some form of dementia. Certainly the most common form of dementia is Alzheimer's disease, and as you may have observed in your practice, cognitive impairment can start many years, even decades, before the actual onset of Alzheimer's disease. Approximately 4% of Alzheimer's disease cases strike before age 60. Some of the worst ones are what we call frontal temporal lobe Alzheimer's disease, and that affects the executive function and changes the personality of young people very, very quickly. Other types of dementia are the result of certainly Parkinson's disease, Lewy body disease, strokes, and other type of physical traumas, which may include motorcycle accidents and closed head brain injuries. Next slide, please. Other vulnerabilities of the elderly is that as we age, older adults often experience emotional instability that represents them more susceptible, especially after a lifestyle change. So we note in the slide here that the first is a death of a spouse, and I can tell you that we have seen many, many cases in which particularly the death of a wife leaves the husband very susceptible to exploitation. And that exploitation today comes in a variety of forms, but fundamentally where we used to think places were safe, synagogues, churches, senior centers. Regrettably, today it appears that there are professionals, women that are out there trolling, literally, for older men to see if they can prey upon them in a big way. I was involved in a case in which a gentleman lost his wife and within weeks found himself sitting next to, at church, where he was a regular, a woman who promptly took him to his accountant and to his stockbroker and moved into the marital home, all within about 6 to 8 weeks of the passing of his wife. So it is critical that you watch your clients, watch your loved ones as life circumstances change, because they become very susceptible to undue influence and to financial exploitation. The studies indicate that as we age, a part of the brain that enables us to detect fraud and other value judgments deteriorates, rendering us less able to determine the honesty of others and therefore more vulnerable and easier to victimize. And I think there's little doubt that as we age, older adults, some of the older adults become more trusting and more susceptible to financial exploitation and undue influence. Next slide, please, Marty. So our next slide addresses who are the likely financial predators. And I think that it is really troublesome to realize that our most common financial predators are relatives. They are usually the children of an older adult or the grandchildren of an older adult. Below in numbers, care is the secondary line, of predators is caregivers. Caregivers come in a variety of shapes and forms, often caregivers that are isolated one-on-one, younger women with an older man in the house, spending 24 hours a day, 7 days a week, literally controlling access to food, controlling access to the outside world, controlling access to visitors, and sometimes controlling access to money. Caregivers are in a position to exploit older adults. We see that exploitation from caregivers in the fashion of trading, unfortunately, sexual favors for signatures. And I call them sex for signatures cases, and that's exactly what it is. It's sign here on a deed transferring your house, sign here on an amendment to the trust, making me a beneficiary, or execute a new codicil to your will, making me the caregiver, the beneficiary of your estate. A lot of these caregiver circumstances also occur in nursing homes where the staff is not observed closely, more often than not on the nighttime shift when the older adult is more vulnerable and there's less people to watch what's going on. So caregivers and relatives. Relatives, unfortunately, often get involved. We see the children of older adults or the grandchildren of older adults get involved in drugs and or gambling or some type of other addictive vice behavior that leads them to need money and steal it from their loved ones. Pretty much down at, I'd say, the bottom of the list, but it's still a high percentage. Fiduciaries are often caregivers. They come in a variety of forms. They certainly come in the form of an agent under a power of attorney for property. That agent today is given complete access, if the document is drafted as such, to allow an individual to go into a bank and basically rob the older adult. I think we're seeing a lot more bank robberies using power of attorney for property documents, which are called different things in different jurisdictions, but ultimately it's naming an agent to manage your financial affairs and have access to your property. It's imperative that we lawyers, as we counsel clients in the preparation of these documents, make certain that the agent selected for the power of attorney of property loves that older adult, loves the principal of the document a lot more than they love their money. Otherwise, it is going to be abused and misused. In addition, other types of fiduciaries include, regrettably, lawyers that are in a position to exploit older adults. This is typically done with the settlement of lawsuits or sometimes on the sale of homes, and the proceeds of sale are then used or stolen. We had a substantial case here in Chicago in which an attorney persuaded the older adults in a neighborhood practice to provide him with the proceeds of sale of all of their homes, and he embroiled himself in a Ponzi scheme, and regrettably they all lost their money. Trustees, of course, are in a position to take advantage as well, and it's imperative that you're putting someone in a fiduciary role, that you make certain that that fiduciary has your best interests at heart and not their own pocketbook at heart. And of course, sometimes there's really no third party. The loss is self-inflicted. Sometimes it occurs by an unscrupulous broker who's interested in churning the account. But the third party or self-inflicted scenarios kind of take on another perspective as we switch to the next slide. The next two slides are kind of an overview of some of the biggest scams that we've observed and that the financial community has observed. And notably, you know, it's all involving theft, and it's theft of various means, mostly con men and women involved in the theft from an unduly influenced, susceptible older adult. And approximately 6 million seniors fall victim to this fraud or various types of fraud every year. And of course, when an individual is cognitively impaired for whatever reason, but certainly dementia or Alzheimer's disease, they become increasingly vulnerable. So our first category is exploitation. You can see it's a huge number, approximately $17 billion was scammed from older adults. It operates by claiming with the consent of the victim. And I think everybody on this webinar has seen scenarios where if you order something one time, that order is continually shipped to your home with shipping fees and the credit card statements being run up on a monthly basis. And the examples there are, you know, quack weight losses, excessive gifts, misleading financial advice, and I've already talked about the hidden shipping scenario. Criminal fraud is close to $13 billion, and that's in the context of really anonymous legal activity, somebody getting into your account, stealing your identity, and abusing your personal financial information and circumstances. Con artists, almost a $10 billion scam. I think that today almost everybody except the people that need to be most aware have heard of the grandparent scam. We literally had a client that got this telephone call over the weekend and was basically told that her granddaughter needed money to get bailed out of jail, and she called us frantically fortunately called us to get involved in a circumstance that required prompt attention. But as noted already, it was a scam. Nigerian prince emails, you know, this is coming from someone who wants to share his wealth with you. Fake lottery winnings, send us the taxes that are owed on the lottery, and you're going to win millions and millions. And a sweetheart scam, I was involved in a case in which a elderly woman here in Chicago Metro was online dating a fella out of Africa. And she absolutely unequivocally could manage her affairs in every area but the online dating scam, and sent him substantial sums of money before her family moved in and had her declared a disabled person. Next slide, please. So the identity theft we talked about a few minutes ago, credit cards, card titles, things like that. It's a multi-billion-dollar scam like the others. The caregiver abuse we've talked about earlier, but I want to remind you that if you have a loved one or a client who is living one-on-one with a caregiver, you should be going to visit that client or loved one at odd times. Do not tell the caregiver I'm coming every Sunday at 10 a.m. because every Sunday at 10 a.m. the circumstances will be perfect. You want to get there at 9 a.m. on Monday and perhaps at 8 p.m. on Friday to really see what's going on. You also want to make sure that your loved ones or your clients have all of their financial records, all of their financial documents, and all of their jewelry out of their condominium or apartment or long-term care facility, wherever they reside, because that's how caregivers abuse older adults. So seniors lose over $36 billion to financial abuse, and it's a stunning increase over prior years. Next slide, please, Marty. Many of us recall Mickey Rooney. Mickey Rooney was a witness, probably the star witness, before the United States Senate Select Committee on Aging. And Mickey Rooney, of course, who was a major Hollywood movie star, was kind of held hostage. Food and water was withheld, and his stepson basically controlled him. He lost over $400,000. His IDs, his passports, and so forth were taken from him. His son took complete control of his finances and forced him to do performances that he didn't wish to do. If you can see the box below Mickey Rooney's picture, you can see Mickey Rooney said, I was eventually, in his testimony to the United States Senate, I was eventually and completely stripped of the ability to make even the most basic decisions in my own life. If elder abuse happened to me, Mickey Rooney, it can happen to anyone. And I think that that's 100% true. Next slide, please. Here in Chicago, we're very proud. The Chicago Cubs won a World Series a couple years back. But poor Mr. Cub himself, Ernie Banks, never got to see the Cubs win the World Series. Mr. Banks, regrettably, was financially exploited in the last months of his life. He had a caregiver, and his caregiver prevented his children from visiting him. And in fact, his caregiver had estate planning documents done 3 months prior to his death. Guess who they favored? Not the children, but the caregiver. So Mr. Cub, who received the National Congressional Medal of Honor from President Obama 5 years ago, died at the age of 83 from a heart condition, and dementia was listed as a significant condition contributing to his death. I want to, in closing on my section, I want to read you a quote. It's referenced in the intro. At the ABA's request, I was the lead author of a book on Alzheimer's and the law, and Scott Turow, an attorney and filmmaker and fiction book leading author, was kind enough to do the introduction for our book. And Scott's mother suffered from Alzheimer's disease, and he wrote in the intro, Alzheimer's disease is one of the scourges of our time, and one whose toll on the country will only deepen with the aging of baby boomers and the inevitability of increased lifespans. Curing Alzheimer's would probably do more than any single step to reduce healthcare expenses, and far more important, to improve the quality of life of the elderly here and around the world. So as we lawyers deal on a daily basis with a growing population of older adults and a growing population of loved ones that are becoming cognitively impaired, I would urge all of you to use caution, use good judgment, and get actively involved in protecting older adults from the financial exploitation that we've discussed here today and that Marty will discuss in conjunction with the new FINRA SEC rules. Thank you.
All right. Thanks, Kerry. For those of you who would like to learn more about Alzheimer's and dementia, I can't recommend too highly Kerry's book that's listed in his biography, Alzheimer's and the Law. Whether you are relatively new to the subject or are fairly sophisticated, there's a great deal of learning in that book, and it's a great source book. I might add one additional scam that Kerry didn't mention. As a retired tax attorney, this always interested me. You get a letter from the IRS, and it's on letterhead that imitates the IRS letterhead very carefully, would fool even an experienced tax attorney, asking for money. My wife got a call from the IRS saying that unless she sent a check immediately, they were coming to arrest her. And she told them they had to hurry up because they had to get there before 4 o'clock. She had a hair appointment at 4. We never heard from those people again. Anyway, moving on to the FINRA rule. The FINRA rule became effective in February, and it allows investors over the age of 65, and in a few cases, those under 65, to designate another adult to be his trusted contact person, whom I will refer to as a TCP. The rule applies immediately for new accounts, but to existing accounts only later on, presumably within a year. Some institutions have started applying the rule to existing accounts already, and most of the rest of them will let you name a TCP before they get around to you. But in those cases, you're going to have to initiate the process on your own, and it's not very easy. If you go onto the online sites for these things, there's usually nothing there to indicate that you can do that or how to do it or what the benefits are. I might also say that even when the broker-dealer comes to you and solicits you to designate a TCP, you're not required to do it. There's no penalty for failure to do it. It's an option. Okay, who can be a TCP? The main requirements, it has to be an adult, it has to be an individual, a human person, cannot be an institution. What is the expected function of a TCP and what can they do? The new rule allows the financial institution to communicate on a confidential basis with an individual you trust and designate in advance for that purpose. It can communicate to discuss fraudulent activity in your account if it sees any. It can also contact the TCP if it believes that you may be engaging in meaningless and wasteful activities like churning an account that suggest dementia or similar problems. Until now, disclosure was too risky for the broker-dealer. Before the FINRA rule was adopted, when a financial institution suspected a problem, privacy laws limited what it could disclose to someone other than yourself. More important, disclosing information to a third party, even a close relative, might actually result in the very financial disaster you're trying to prevent. The person the financial institution contacts might well be the financial predator. Disclosure only enhances his ability to take advantage of the intended victim. For example, the financial institution's communication might disclose the existence and location and the balance in an account the predator didn't even know about, and it was information the investor intentionally wished to withhold from that person. Even communicating concerns to a spouse can create problems. It might result in the unwanted disclosure of sensitive financial information in a bitterly contested divorce proceeding. And some of the reported cases involved a second marriage where each spouse had children from a prior marriage and the interests of the husband and wife were adverse on financial matters. Okay. How to appoint a TCP. For new accounts, the financial institution will solicit a designation from you. They are under an obligation to make reasonable efforts to get you to do that, but there is no requirement that you do it. And if you refuse to do it, the financial institution can go ahead and handle the account in a normal way. In those cases where it has not solicited you and you want to do it ahead of time, then you're going to have to go to the website and work through the options. Now, what are the benefits? The benefits are if the financial institution contacts the TCP and warns him or her of potential financial abuse, the TCP can take any of the following actions. They can contact law enforcement agencies for help. They can contact adult protection services. They can arrange for a medical consultation. They can arrange with the assistance perhaps of police to remove the suspected predator from the house, or to remove the predator, to remove the victim to a safer location out of the reach of the predator. Almost as a last resort, because it's very expensive and inefficient, they could commence a guardianship or conservatorship proceeding. Or perhaps after discussing the matter with the investor, the TCP can decide that nothing is wrong and just ignore the warning. Whether or not you opt to designate the TCP, the new rule allows a broker-dealer to suspend temporarily any distribution to you while it investigates the situation, if it has a reasonable belief that you are being defrauded or otherwise subjected to financial abuse. It does not seem to apply if it only suspects that you're doing the damage all by yourself. For example, if you're churning the account, it does not justify a suspension of the distribution. If it does suspend the distributions and you have designated a TCP, it is required to inform the TCP of that suspension. But keep in mind that all of this is completely optional for the institution. You can always opt to do nothing at all, even in cases of clear-cut fraud. We hope that most institutions will not choose that route, but they are protected if they do. Personally, I regard that as a serious shortcoming. Reporting to the TCP fraudulent or even highly suspicious activity should generally be mandatory. After the rule took effect, I contacted several leading financial institutions and was able to designate one TCP at each one for my existing accounts. None allowed me to designate more than one TCP, although one permitted me to designate an alternate TCP who could be contacted if the primary TCP was unavailable. However, I was recently notified by a financial institution that in the case of certain checking accounts for two grantor trusts, it would treat every person who was an authorized agent for that account as a TCP. The authorized agent was defined as anyone with trading authority or a power of attorney or a trustee on the account. It would also allow the investor to name additional TCPs. The result is that for such an account, I can have multiple TCPs, something we've been urging, but it can also result in providing confidential information to someone I have not designated. The fact that someone has a power of attorney on the account or is a financial advisor with trading authority does not necessarily mean that I want that attorney, in fact, a financial advisor, to be privy to my confidential medical conditions. So at no time would we recommend that someone not specifically designated by the investor be deemed a TCP or otherwise provide confidential information. To my knowledge, no financial institution has yet committed itself to alert TCPs of suspicious activity, such as a change of beneficial interest, naming someone not apparently related to the investor. Our Committee on Financial Services and Retirement Planning intends to collect as much data as possible on how this rule is being applied. And we invite all the listeners on this webinar to forward to us their experiences with their own financial institutions on this subject. Were you able to name more than one TCP? Did they commit to giving alerts to the TCP for any reason? In fact, did they give any alerts? That's the type of data we would like to collect. Obviously, anything forwarded to us will remain confidential. In addition, when you forward anything to us, you do not need to name the financial institution. Just try to describe what happened. Now, let us consider whether you should, in fact, try to take advantage of this opportunity. If so, how should you choose a TCP? Whom should you designate? And the answers to these questions are not always obvious. Most important, you have to be comfortable with the idea that the financial institution may disclose to or obtain from your TCP confidential information, including about your mental state, competency, medical issues, and other private matters. You have to be willing to let the institution provide complete financial information about your accounts, including the names of beneficiaries of the account after you're gone. However, it does not have to be someone with online access to your account or the ability to actively manage the account. With all of this in mind, I suggest that you name someone you do not name someone who might be expecting an inheritance from you, but whom is not named as a beneficiary in the account. That could be embarrassing, to say the least. Similarly, you may want to think twice before designating someone who is a beneficiary of the account if there is a significant chance that you might later change your mind about that future gift? Would you be embarrassed if the institution alerts the designee that his or her interest has been reduced or even eliminated? Also, try to find someone who is younger than yourself. Just as it's inadvisable to appoint someone who is 90 years old to be the trustee of a trust intended to last 20 years or so, someone who's likely to have his or her own aging problems may not be the best choice, either other than as a temporary stopgap. Other factors and complications. Surprisingly, the new rule doesn't require that your TCP be notified of the designation or that the TCP agree to serve, nor does it describe the TCP's duties and obligations or whether the TCP should be compensated. For these reasons, it makes sense that you should consult with any potential designee to make sure that the person understands what is expected and is willing to serve. You should also advise your TCP to accept communications from the financial institutions. These days, I personally refuse to answer the phone if I don't recognize the caller ID, and I think a lot of other people are beginning to do the same thing. So you have to make sure that your TCP will recognize the caller ID from the financial institution and answer it. Now, there has to be also some understanding of what your TCP should do with any information that it gets. If your TCP is a professional advisor, such as your attorney, it's probably appropriate to discuss compensation. You may also wish to pre-authorize the attorney or advisor to exercise discretion to discuss confidential matters with others, including medical personnel, law enforcement agencies, or adult protection agencies. You may also want to specify which family members the attorney or other advisor may contact and which ones shouldn't be contacted under any circumstances at all. Let's move on to another question that comes up. I'm frequently asked, why isn't a power of attorney just as good to protect yourself? As Kerry has pointed out, there are a lot of problems with powers of attorney. In fact, giving someone a power of attorney may just enhance the ability of the predator to take advantage of you. Another short answer is that it's too easy for a predator to cancel an existing power of attorney, even a durable one, without ever notifying the current holder of the termination. Another short answer is that a power of attorney may actually, well, I've already made that point. Remember that 1/6 of the reported losses are to attorneys, in fact, and other fiduciaries. More important, holders of powers of attorney are often spouses or children who rarely have the time or skill to audit the account effectively on an ongoing basis. That takes a very specialized, expensive, and dedicated type of financial expert, whose monthly services would probably be far too expensive for most investors. Keep in mind that even reviewing monthly statements will often come much too late to do any good. If the theft occurs, for example, on the first day of the month, and the statement comes in 5 or 6 weeks later, and the reviewer doesn't look at it for another 2 weeks, it could be 8 weeks before someone sees a transaction that might be suspicious, and by that time, the money has long been gone. But even more important, just reviewing a financial statement, even if you're an attorney or a CPA, and you have time to look at it carefully, you won't find crucial information on the monthly statement. You won't see on most statements that there was a change of beneficiary or a change in contact information or a change of a password, or there was a new bank linkage on the account. That doesn't show up on many financial statements. And in fact, one of the new robo-computers, robo-brokers, if I can call them that, doesn't even give them monthly statements. If you want a monthly statement, you have to go online yourself and download it manually. So monthly statements don't really provide the information that the holder of a power of attorney will be able to use to detect most frauds. Another point is that if the power of attorney is a non-individual, and some people give powers of attorney to banks or other institutions, that attorney, in fact, can't be named a TCP, and as a result won't get the alerts from the financial institution of suspicious transactions. That alert is the most important feature of this whole arrangement because it can identify problems that don't appear elsewhere on financial statements. Nor will that attorney be warned that distributions are temporarily suspended. What else will the designation of a TCP not do? Merely because the TCP has been designated as such The TCP won't necessarily have the ability, the interest, or the time to monitor the accounts and detect red flags. What are those red flags? Here's some typical ones. A change of the contact information is perhaps the first step that a predator may attempt. He or she may also try to add a new bank leakage. Perhaps most onerous would be a change in the beneficiaries and the death of the investor, substituting the predator's friends or families for the investor's family. As an example, there was reported in the newspapers recently, the wife in a second marriage changed the beneficiaries on an IRA account to her own children, disinheriting the investor's own children. By the time they discovered this after the death of the investor, the money was long gone, and of course, so was the wife. A change in the TCP may also be a significant red flag. Unless the financial institution warns the TCP of these red flags, or the TCP has other means to monitor the financial activities and has an independent ability to detect financial irregularities, and does so on a constant and continuing basis, the TCP will not be able to protect you. The financial institution is not required to provide warnings to the TCP unless it is suspending distributions, and even that is a voluntary act. Okay, so what are some of the reasons for more reasons for not designating someone? One risk is difficult to avoid. While you may wholeheartedly trust the person you designate to be your TCP, there's a clear danger that you've been misled into trusting that person. There's also a danger that while trustworthy today, that person may become less so later on. Even honest people change, especially as the lure of easy money arises and relationships cool over time. And as the TCP himself ages, personality capabilities change. You will need to make periodic reviews of your designation from time to time to make sure that that trust and friendship are still warranted, and that that specific designation is still your best choice. But even if at some future time you perceive that problems are arising with that relationship, you might be reluctant to let that person know that you're canceling that designation as a TCP. In practical terms, you may be locked into that designation when it is no longer appropriate. Another problem is that designating a TCP or giving someone a power of attorney will generate a false sense of security. If you think that this is really protecting you, you may be careless about taking other necessary steps. Putting all this together, last year, the Senior Lawyers Division submitted to the House of Delegates of the ABA some proposals, some guidelines, among which were that the investors should be allowed to designate at least 3 TCPs, because that would reduce the risk that a single TCP turns out to be the bad guy. Because if you have 3 TCPs getting the alerts and one of them is misbehaving, the other 2 will be able to spot it. And we also urge that the TCP should be alerted to all important red flags, that it should be mandatory. For various reasons, we withdrew that resolution before it went to a vote in the House of Delegates, but it is likely that we will revise it and resubmit it at a future time. But without those protections, we have problems with the current arrangement. Putting together the pros and cons, unless and until the financial institutions agree to provide these notices on a regular and ongoing basis, the cons may outweigh the pros for most investors. The balance would tip more toward the pros if the financial institutions permitted the designation of 3 TCPs, not just 1, but even that would not be sufficient to alter the balance unless they do make a practice of notifying the TCPs of red flags. Conclusion. At this point, I'm not sure I would recommend to most individuals that they appoint a TCP. The downside may exceed the upside. For some, it may be advantageous, but you have to be very careful about it. And I guess that summarizes my presentation. And at this point, I would open this up to questions from the audience. Oh, let me make one more point before we do that. I wanted to add this comment. One of the people participating in one of our sessions objected that if she makes a gift to a new romantic interest, she didn't necessarily want the financial institution to alert her children. In effect, she thought that it would be none of their business and didn't want them trying to pry into her private personal affairs. If that's a real concern, you don't have to use the TCP process, and you don't have to name your children as your TCPs. But let me put the shoe on the other foot. Suppose a 95-year-old resident of a nursing home names one of the home's workers as a prime beneficiary of an account holding his lifetime savings. Shouldn't someone with that resident's best interest be alerted? And if that 95-year-old resident were your own parent, would your answer be different? These are questions all of us have to answer for ourselves. Okay, thank you. It's time for questions.
Marty, we have a series of questions that appear on the screen.
Okay.
This is Kerry Peck. One of the questions was to repeat the name of the book. The book is The Alzheimer's and the Law. It's published by the American Bar Association Press.
It's a long question here about trust. Let me read it. The power to make an amendment to the trust during surviving period implies the trust can be amended instead of outside court jurisdiction. When this is the case, court exercising jurisdiction, they cannot render any enforceable orders. When banks exercise these orders, banks are becoming parties to death. Where is FINRA? I don't quite understand the question. Does that make any sense to you, Kerry?
I'm sorry, I don't understand it either.
I don't think FINRA. I don't know that FINRA. Sounds like my voice is creating problems again. Okay, we repeated the name of the book.
Are there additional questions that we can answer here, Marty?
Yeah, apparently people are having trouble with the sound from me.
Question 9 is, do we know how many durable power of attorney agents are banks or entities rather than a relative or individual? I don't know that we have the results of any studies on that, but I think that in the normal course of business, banks are reluctant to act as power of attorney for property. They may do so if they have an ongoing trustee relationship, but there aren't a lot of institutions that are, in my opinion, seeking out that kind of business. As I previously said, I think they may do it if they have a existing business relationship with the potential principal or customer.
There's one question here. Please confirm that the TCP issue arises under FINRA and thus relates primarily for brokers. Please confirm that FINRA does not extend to banks to the extent they are not providing broker-dealer services. The TCP authority is solely for members of FINRA, and that normally is broker-dealers. However, banks will often get involved because they have broker-dealers or affiliates, and therefore the requirement will extend to those banks as well.
Question, what if the caregiver has the password and logs in without having a power of attorney? I think that that's a very significant problem. It is a very common method for a caregiver to abuse financially an older adult. And, you know, the only way to prevent that is to make sure the caregiver doesn't get the login or password information. They certainly don't need a power of attorney to log in from the computer of the older adult who they may be the caregiver for. So there's really no, you know, at the end of the day, we're back to get personal information, financial information out of that house, out of the condo, out of whatever living circumstance the older adult lives in.
Yeah, I might add, once you've got a a problem with Alzheimer's, it's very easy for the caregiver to get any of this information. She just asks the victim, "What's the password for this account?" Or the victim actually asks the caregiver to help him log in because he doesn't remember his own password. Caregivers get money in many ways. They go to the victim and say, "You owe me my salary. Please sign this check for $500." So he signs it, and he comes back in the afternoon and says, "You haven't given me my salary this week. Please sign the check for $500." And he signs it again. Or the check isn't for 500, it's for 5,000. So once you've got a situation where there's significant cognitive impairment, the caregiver has many opportunities to take advantage of it.
Yeah, I agree. I think that, at the end of the day, we're talking about taking preemptive action in all of these circumstances, whether the decision is to use the TCP or not. We're also talking about some practical applications of just good judgment in keeping people from being financially abused. Please, note and remember that there is an ABA model rule 1.4 that addresses how attorneys should deal with cognitively impaired clients. So no matter what your area of practice today, whether it's, trust and estates all the way up and down the line to patent law, personal injury law, real estate, or any other substantive area of law, with the aging of America and the growth in the number of baby boomers that are obviously aging in place, lawyers today are encountering cognitively impaired clients with a stunning amount of frequency. I urge you to take a look at Rule 1.14 because that rule allows you as a lawyer for the first time the opportunity to take your problems that you're facing with a cognitively impaired client to a third party for consideration. You may be able to consult that individual's doctor. You certainly are able to consult that individual's other family members. We lawyers have been taught since day one that in accordance with Rule 1.6, confidentiality, we can't breach confidentiality. But if you have a cognitively impaired client for whom you are concerned may be exploited, or for whom you're concerned can't manage their own affairs, you are entitled under Rule 1.14 to breach that confidentiality. It's no longer considered a breach, and to consult with experts and family. So I would urge the listeners here to take a look at that rule. It's a game changer.
The question here seems the answer is obvious. Is it a crime for a caregiver to log on as you if they aren't named as the agent in a DPOA? I think it's obvious that it's a crime. All of these things that we're talking about are crimes. And then further, FINRA does not protect the account holder when the financial institution undertakes transactions without authorization from the account owner. Or when the financial institution undertaking transactions without authorization, the TCP is a liability. Well, I agree that they're not allowed to do it, but I'm not sure why having a TCP is a liability rather than a help. It would seem to me just to be a non-event. Gary, do you understand why it'd be a liability?
I'm not sure I understand what that is.
I mean, clearly a financial institution is not authorized to do the transaction if it's not specifically authorized. And that's one of the problems I have with the letter I got about my grantor trusts, because they are naming people as TCPs that I have not designated. But I don't know why having a TCP is a liability.
I'm not sure I understand. I mean, I think fundamentally the TCP is there. We may differ on how many there should be and so forth. to protect the account holder from financial exploitation. You know, under this rule, the financial institution is now for the first time given the authority to freeze the account. And this is quite a dramatic change in existing rules, because up until the existence of this rule, banks and financial institutions have been very reluctant and usually won't freeze the assets of an older adult. And in my practice, we've gone into probate court literally hundreds of times to freeze the assets of older adults that we believe are being financially exploited. Of course, the condition precedent there is we need to allege and have a medical report indicating that they are cognitively impaired and thus susceptible to this type of financial exploitation. So this rule, I've already said earlier about the Code of Professional Responsibility, but this rule is also a substantial game changer in that it allows financial institutions to take this action if they reasonably believe that someone is going to be or is being financially exploited without liability to the financial institution. So that's really a great change, in my opinion, in the law.
Well, let me comment. We didn't go into this because it doesn't really relate to TCPs, but the authority to suspend distributions is a temporary one. Originally it was going to be 10 days. Now I think it's up to 25 days, although I don't remember the exact number. And that just time to investigate. And under some circumstances, they can extend it. But even to initiate the suspension, they have to have a reasonable belief of financial abuse. It's not a power that can be used willy-nilly.
I agree. And under the new rule, the financial institution or broker-dealer is obligated to train the staff in the use of this rule. So that's also a change in the SEC regulations and FINRA regulations. Are there other questions here that we can answer?
Well, if that's it, I thank everyone and turn it back over to Austin.
All right. Thank you, Marty and Carrie, for your insightful discussion on the new rule on trusted contact persons. And thank you all for joining today's webinar, Trusted Contact Persons, a new tool for protecting the investment accounts of seniors. Attendees, be sure to check out our website at ambar.org/srlawyers for all Senior Lawyers Division activities and publications. Recording of past programs are on the website now, and you can like our Facebook page to stay up to date. Before leaving, please complete our short survey. Thank you again, and have a great day.